Good afternoon and compliment of the season. Merry Christmas to all our listeners. Uh, Thank you again for a beautiful Wednesday like this. Today, we continue with our weekly podcast. Remember to invite your friends, family. Can you please help me log in? So, we are continuing our citizenship series. But today we'll be dealing with what's the topic? Okay, how criminal activities affect citizenship. That is the topic for today. So remember to invite your family, friends, colleagues to join us. We do this every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. That is 1 p.m. Eastern. That is 10 a.m. Pacific. And currently, I think it's about 7 p.m. Nigerian time right now. So, we are continuing with the series on citizenship. So, if you have questions, today we are discussing how criminal activities impact citizenship in the United States. That is the topic for today. So, if you have questions, send in your question. Can you post the numbers, please? Okay, send in your questions. You can text us on WhatsApp 817-883-4499. 95. Okay. 817. Can you please enlarge the number? I can't say it very well. 817-883-4495. So you can send in your question through WhatsApp. You can also send in your question through 817-883-4495 or 817-983-4499. 817-983-4499. You can send in your question. So, while waiting for questions, let me give an overview. We've been discussing citizenship series in the last few weeks. So we continue today on how criminal activities impact the ability to become a U.S. citizen. Generally, the requirement of citizenship is different from the requirement of green card. There are some criminal activities that may not impact your ability to become a permanent resident, but may impact the ability to become a U.S. citizen. It does not matter where the criminal activities occurred, whether it occurred in the United States or outside the United States, it is immaterial. It does not matter how long the crime occurred. That depends on the nature of the crime and the severity of the punishment. There are some criminal activities that can create a permanent bar to citizenship, especially criminal convictions relating to sexual offenses, relating to pornography, relating to child trafficking, relating to offenses against minors generally, and of course capital offenses like murder and all. Those kind of offenses create permanent bar to citizenship. And most of the time, it also leads to deportation. Even if you are a permanent resident, it can still lead to deportation from becoming a citizen. For example, one of the major differences between the requirement of U.S. citizenship and the requirement of being a permanent resident is what is called good moral character. So for green card, you can get your green card even if you lack good moral character, especially if you are not convicted of the offense. Or even where you are convicted, you can still apply for some waiver, criminal waiver, and you can still get your green card. But when it comes to citizenship, the requirements are different because lack of good moral character is a disqualification for citizenship purpose. So even if you have not been convicted, you can still be you can still be denied citizenship. For example, if you commit misdemeanor, maybe traffic violations, if you have multiple traffic violations, citizenship could be denied on the ground that one, you lack good moral character, two, you have no regard for the laws of the land. Even though you will just be wondering, is this not a traffic issue? Yes, traffic issue can disqualify you from becoming a U.S. citizen. Other moral offenses, like being drunk, if immigration see you as a drunkard, that is something too that can prevent you from becoming a U.S. citizen. Excuse me. So you don't necessarily have to be convicted for drinking. Although if you have DWI, driving while intoxicated, of course, that will also prevent you from becoming a U.S. citizen. However, there's a difference between capital offenses and minor offenses when it comes to citizenship. Capital offenses, they are offenses that are categorized as aggravated felony. So if you are convicted of an aggravated felony offense, that will not only disqualify you from becoming a U.S. citizen, it can also be a removable offense. So the impact may be a permanent impact. On the other hand, if your offense is a minor offense, it will depend on when that offense occurred. Generally, when you have a green card, from the day you become a permanent resident, you are not expected to be convicted of any offense for 5 years. So initial 5 years. So even if you committed a minor offense, like misdemeanor offense, traffic-related offense, or other misdemeanor offense, if you are convicted, let's say 4 years after becoming a permanent resident, and you are required to be a permanent resident for 5 years before you are eligible for citizenship, once you are convicted of that minor offense, for 5 years, you will have to restart it from the date after the conviction. So if you have a green card, and your green card category requires you to be a permanent resident for 5 years before applying for citizenship, if on the 4th year of your permanent residency you are convicted of a minor offense, you will not be able to meet that 5-year eligibility requirement for another 5 years before you can become a citizen. So now, instead of waiting for 5 years, you will end up waiting for 9 years because the initial 4 years will have been erased. So you start the process all over again. So those are temporary setbacks for eligibility for citizenship. But when the offense is an aggravated felony, that one is a permanent bar to citizenship. And of course, once there is a permanent bar to citizenship, usually there are some offenses that create a removable situation, but where you are able to apply for a waiver. In those situations, if you are able to apply for a waiver, the waiver may also waive the disqualification bar. But usually, these are not criminal offenses. These are immigration violations. The categories of offenses in this category, they are immigration violations. There is a difference between immigration violations and criminal violations. Immigration is not considered a criminal offense. So if you violate immigration law, that is not considered a criminal offense. So if your violation requires a waiver, if you are able to get a waiver for the violation, usually it will also waive the disqualification or whatever the number of years, days, weeks, months that has been erased. It will waive it. But when it is a criminal conviction, it does not. So if it's an offense that is not aggravated felony, you have to wait another 5 years or 3 years, as the case may be, depending on the category you are applying from. For example, if you are the spouse of a U.S. citizen, you only need to wait 3 years, not 5 years. But if you got your green card through employment based, then you need to wait 5 years. So it depends on the category. And of course, there are other categories as well. If, for example, conviction on the ability to become a U.S. citizen. So start sending in your questions, because sometimes I can go on explaining some of these things and it may not answer specific questions that viewers may have. So if you have questions, you can send them in. I can see that a lot of questions have come in. So I'm going to start reading out and answering the questions. Okay, the first question. What crime can cause a citizen to lose citizenship? No. There is no crime that can cause a U.S. citizen to lose citizenship. Once you are a citizen, you are a citizen. You cannot, a U.S. citizen who committed any crime at all, the greatest crime anybody can commit is murder. So even if a U.S. citizen committed murder, they cannot take citizenship from the person. You are already a citizen. So whatever they do to Americans who committed murder is what they will do for the person. So no criminal activities can deprive a U.S. citizen from being a citizen. Even if you turn out to be terrorist, they will just arrest you and send you to jail or do whatever they do to people who committed crime. So no criminal activities can deprive a U.S. citizen of a citizenship. However, having said that, that does not mean that a U.S. citizen cannot lose citizenship. All I've just said is that no crime can deprive a U.S. citizen of citizenship. However, there is only one condition under which a U.S. citizen can lose that citizenship. And that condition is if you obtain the citizenship by fraud. It does not matter how long. Even if it is 50 years ago, if it is 70 years ago, if you obtain the citizenship by fraud, that citizenship can be taken away. That is the only time a U.S. citizen can be taken away. That is the only time that a U.S. citizenship can be taken away, because you cannot build something on nothing. So if the citizenship was obtained by fraud, at any time when the fraud becomes known to the government, they can always take the citizenship back from you. I remember some years back, there was somebody who participated in Nazi genocide during the Second World War. And that person has been living in the US for about 70 years. And then they found out. They connected his link to the genocide. And guess what? They went through his immigration record and realized that he didn't disclose that activities. Of course, they took the citizenship from him. They took it from him. I also know of another person. In fact, this person is even a Nigerian who obtained citizenship over 20 years ago. But at the time that he applied for green card, he changed his name and he didn't disclose the new name. So when there was a question, have you ever used any other name? He answered no to that question over 20 years ago. Unfortunately, for some reason, the government got to know about that name. And now they accused him of obtaining the citizenship by fraud. So the only time U.S. citizenship can be revoked is when the government is able to prove that that citizenship was obtained by fraud, not by commission of a crime. If you are a U.S. citizen and you committed a crime, it is immaterial, except if the crime has been committed before you became a citizen and you didn't disclose it, and they found out later. Yes, that is still considered obtaining citizenship by fraud. So the next question, will a misdemeanor affect naturalization? Oh yes, it can affect naturalization if it happened within the first 5 years of becoming a permanent resident. Every permanent resident, green card holder who obtain, everyone, it will disqualify the persons. Yeah, it can impact it. However, the effect is that you wait and you start counting the citizenship eligibility from the date of conviction. So whatever dates, whatever days, months, weeks, or years that has been accrued prior to that conviction will be erased. So you have to start the counting all over again. The next question, do I need to tell USCIS about my traffic offenses? Could this bar me from citizenship? Oh yes, it depends on the nature of the traffic offense. If it is traffic offense as in you get a citation and you went to the traffic office and pay it, that is immaterial. That will not have any impact. But if it's a traffic offense that led to you being arrested, yes, you have to, because non-disclosure will create a problem. Remember, anybody applying for citizenship, the immigration will have to run the background. They have to use your fingerprinting to conduct a comprehensive background check. Anytime you have been arrested in this country, even if you are wrongly arrested, anytime you have been arrested, your fingerprinting is already in the system. So if you don't disclose it, by the time they run your background check, it will show up that you are arrested at a particular place for a particular offense. Then your citizenship application will be denied on the ground that you lied in your application. Of course, you have to disclose it. Yes, traffic offense can impact citizenship where there is arrest. But if it is just police stopping you along the way, gave you a citation, you went to the office and paid the citation and you came back, no, that does not have any impact because no fingerprinting is involved. So that is not considered arrest. And except immigration becomes except they apply supernatural authority, I don't see how they will see that, because there will be no record of that. That will only reflect in your driving record, which is not considered. So when they use the word ever, it means forever. Since you are born, have you ever been convicted of a crime? So you have to answer. So it doesn't matter how long ago. Have you ever been usually there are a series of questions. Have you ever been arrested? Ever? So even if it is 50 years ago, you still have to answer yes. Because if you answer no and then they found out, it becomes a problem. So you still have to answer yes. Have you ever been convicted? That's a separate question. You still have to answer yes, no matter how long. So that's why I said forever. Another question, have you ever committed an offense for which you are not arrested? You still have to answer yes. If you know that there was an issue, maybe you were investigated or something happened, which of course the government may have information about at a later stage. So it's always better to disclose it and then address it at the point of citizenship than to leave it and then it can turn around to work against you in the future. Yes, it's always good to disclose it. So the answer is yes, it goes back forever to the day you were born. So the next question, what kind of background check is done for naturalization? Extensive background check. Remember when I was explaining the requirement of naturalization, it goes beyond criminal activities. It involves moral disqualification. Good moral character is a requirement for citizenship, is a requirement for naturalization. So even if you are not convicted, you know, when we say somebody lack good moral character, you may not have been convicted of any offense, but you, for example, if you are a drunkard, you may not have been convicted, you can still be classified as having good moral character. And I remember in the past, I once represented a citizenship client who applied for citizenship no criminal offense, no criminal arrest, nothing. The only thing was that he was owing taxes. He was owing IRS. Meanwhile, even though he was owing IRS, he had arrangement with IRS to pay the debt installmentally. And he has not even defaulted. He was paying the amount agreed monthly. And we presented all the evidence. But immigration still denied it on the ground that he lacks good moral character. That if he didn't lack good moral character, he should have paid those taxes as at when due. Because in his case, he was actually audited, and then IRS determined that he owes some taxes. Then he made an arrangement with them to pay installmentally, and he never defaulted. But they used that to disqualify him from citizenship. So I had to advise him to raise money to go and pay off the debt, and then we reapply for citizenship. And luckily, they approved it the second time. But again, that is just telling you that the difference between criminal conviction and moral judgment is still it has a lot of impact in the application for naturalization. The next question: does bad credit affect citizenship application? No. Bad credit has nothing to do with it. That has to do with you. If you don't have good credit, that impacts your life. That has nothing to do with your eligibility. Remember, you are already a permanent resident. If you are not a permanent resident, if you don't have good job, that may be an issue, because that is why at that stage you have to provide affidavit of support to show that you will not be a public liability. But what we are discussing citizenship here, and everyone who is applying for citizenship is presumed to be a permanent resident. So the issue of you not having good credit is immaterial at this stage. Nobody is required to present affidavit of support in order to become a citizen. No, that is not a requirement. The next question: can you become a U.S. citizen after a felony? It depends on the nature of the felony, because for immigration purpose, the way immigration law defines felony is different from the way most state laws define felony. For immigration, felony is determined based on the length of the conviction. For example, even if you committed a non-felony offense, even if you committed a misdemeanor offense and you are sentenced to 12 months imprisonment, as far as immigration is concerned, that is considered aggravated felony, because it is the length of the punishment. In fact, even if it is 12 months probation, it may still be considered aggravated felony for immigration purpose, because it is the length of the punishment that immigration uses to characterize aggravated felony. So certain offenses which may naturally under state law may not be considered aggravated felony. For immigration purpose, it will be considered aggravated felony. For example, I mean, the use of marijuana is lawful in some states, but is that not what it's called? What other name do they call it? Okay.
No, it just caught my attention that you mentioned it.
Okay. Yeah. So, but as far as the federal law is concerned, it is still an offense. It is still an offense. So this is something that can disqualify you from becoming a citizen, even though it may be legal in the state where the use of the marijuana occurred. Let me look at the question again. Okay, can you become a U.S. citizen after a felony? Yes. The answer is yes. You can become you can still become a U.S. citizen, because it depends on the nature of the offense. And that is why I'm explaining what constitutes felony and what does not. So in some cases, the offense may be classified as a felony under federal law, but in actual fact, it may be a simple offense. And that is why I gave you some example. Another example, under immigration law, once somebody is convicted of stealing, theft, for immigration purpose, it is considered aggravated felony. Even though under the state law where it happened, it may not be aggravated felony. They may not even charge it as aggravated felony. They may charge it as a misdemeanor, first degree misdemeanor or second degree misdemeanor. So it does not really matter. But as far as immigration is concerned, once it is a theft offense, it becomes aggravated felony. So all those things, the fact that you have been convicted of aggravated felony does not necessarily mean that you are barred from becoming a citizen. That is why I explained from the beginning that there are some offenses that create a permanent bar, and there are some offenses that create what I call a temporary bar. So in which case, if you are convicted of some of those offenses, you have to start accruing your citizenship requirement. You have to start all over again. So if you are required to be a permanent resident for 5 years, maybe 4 years into it, you are convicted of aggravated felony, you have to, if it's a temporary one, you start counting the 5 years all over again, but you can still be eligible for citizenship. The next question: do felons lose citizenship? No, I think I've already answered that. If you are already a U.S. citizen, no matter what you commit, it is immaterial. If you are already a U.S. citizen before the offense, it does not matter. The greatest offense anybody can commit is murder. So even if you commit murder after becoming a U.S. citizen, it does not impact your citizenship. You will only face whatever punishment is required for anyone who committed the nature of the offense that was committed by you. The next question. Before I go into the next question, now we are discussing immigration here. I'm not discussing civic liability or civic responsibility. So even as a U.S. citizen, if you commit certain offense, you may lose certain privileges. For example, I know in some states, some people who are convicted of aggravated felony are not allowed to vote. So that has nothing to do with citizenship. So we are discussing citizenship here. So if you are already a U.S. citizen before you commit any offense whatsoever, it does not impact your citizenship. The only offense that impacts citizenship is if you obtain your citizenship by fraud. That is the only thing. Any other thing does not impact citizenship. The next question. What does USCIS consider a misdemeanor? What does USCIS consider a significant misdemeanor? Well, it is not the USCIS that determine what a significant misdemeanor is. Remember, USCIS does not create criminal offenses. It is usually state law or federal law that creates criminal offenses. Most of the time, people are convicted of criminal offenses based on state laws. But again, there are also federal crimes. For example, if your criminal activities involve maybe defrauding IRS, defrauding Social Security, those are federal offenses. Or maybe it has to do anything that is federal offense, that is governed by the federal law. But it is not USCIS that classify offenses. It is state laws that classify offenses. And that is why immigration came up with a blanket rule, so that even if your activities in one state does not amount to a crime or does not amount to a felony, if it does in another state, they don't want to be bothered by things like that. That is why they set up a blanket rule where they use the criminal conviction to determine whether your offense is a felony or is an aggravated felony. And that's why I gave the example that if, for example, you are convicted of a crime and you are sentenced to 12-month probation, as far as immigration is concerned, that is an aggravated felony. It doesn't matter whatever it is at the state level. It is an aggravated felony as far as immigration is concerned. Once you have been given up to 12 months, either jail term or probation. Immigration does not even differentiate between probation or serving jail term. They just have that blanket rule. So that is why it is because each state determines what constitutes. So you can be convicted of a particular, you can engage in a particular action in one state, and that action may not be criminal. But in another state, the same action can be criminal. That's why I gave an example of drug use. I do know that in Colorado, for example, using marijuana is not an offense. But in Texas, it is. So you cannot do something because it is not a crime in one state and then you do it in another state. In another state, it may be a crime. But immigration does not want to start looking at, oh, is this a crime in this state or is this not a crime? They don't care about that. What they are concerned about is the conviction. So if you are given 12 months, either jail term or sentence, as far as immigration is concerned, that is a felony. That is an aggravated felony. So it is state laws that determines what is a significant misdemeanor or a misdemeanor or a felony or an aggravated felony. So the next question, can citizenship be denied because of unpaid taxes? Oh yes, I just gave an example just now. Yeah, citizenship can be denied based on unpaid taxes because that will be classified as lack of good moral character. So somebody who lacks good moral character he can be denied citizenship because that is one of the differences between the requirement of citizenship and the requirement of permanent resident. So somebody who owes taxes can be given green card, but the same person can be denied citizenship because the requirement of citizenship include having good moral character, and non-payment of taxes is classified as lack of good moral character. The next question, can USCIS expunge record? Am I supposed to disclose them? Oh yes. Let me tell you, this is a very good question because I see this type of question all the time. Can you please note that question for the real? I see this question all the time. Let me tell you, as I've explained earlier, criminal activities are generally governed by state laws. Criminal activities are generally governed by state laws. There are a few federal criminal offenses, but majorly 90% of criminal activities are involved with state laws. So, if you commit a crime, if you are convicted of a crime, and then after serving the punishment, after meeting certain conditions, that criminal record is expunged. It is only expunged at the state level because these are based on state crimes. Immigration does not use state resources in conducting background check. They use federal resources in conducting background check. In fact, background checks are conducted by FBI. FBI can see everything, including expunged crimes. But when a state crime is expunged, of course, when you apply for a job, employers will not be able to see it. When you apply for certain things, they will not be able to see it. when maybe you apply for a rent or whatever you apply for that requires conducting a background check on you, this crime will not come up because it has been expunged. But when you are applying for immigration benefit, the FBI will still see it. Even though it has been expunged, they will still see it. It does not matter how long ago. The record will still be seen by the FBI. So it is better to disclose it, because usually when you disclose it and then they realize that the record has been expunged, it is a sign that that record is not significant, because usually offenses that are significant cannot be expunged. But when you don't disclose it and then the immigration found out, now it becomes a problem, because now you are now lying to obtain benefit. So your citizenship is not only going to be denied because of the lie, because of the expungement of the crime, but it is now going to be denied because you lied about it. And this is not limited to citizenship. Even this one affects green card. So if you committed a crime before your green card and that record was expunged, if you are completing application for permanent resident and they ask you about it, you better disclose it. Because if you don't, FBI will find out. And when they do, they will count it against you that you lied in order to obtain benefit. The next question. What are considered crimes of moral turpitude? Of course, I think I've answered that several times. I've given different examples. Crimes, well, different states have rules and even case laws that determine crimes of moral turpitude. Usually, multiple misdemeanor offenses are considered crimes of moral turpitude. Usually, felonies, crimes of moral turpitude. As I gave an example before, stealing, as far as immigration is concerned, it doesn't matter what the state law says. If somebody is convicted of stealing, it is a crime of moral turpitude. So, but in some cases, some criminal activities may be for stealing. It is considered a crime of moral turpitude all over the United States. The next question. What is the most serious misdemeanor? Well, again, talking about state laws, it depends on how state law classifies certain offenses. For example, most states, they don't classify DWI as a felony. Most states classify DWI as misdemeanor. So when you now have a I don't know why I keep mentioning DFW. When you now have a DWI that involves maybe involve maybe the kind of accident where people's life were at risk, where that created serious bodily injury, that will be considered, even though DWI is still considered a misdemeanor, it will be considered a significant misdemeanor because of the bodily injury. Now, if you now have more than one of that kind of offense, it becomes aggravated felony. So the next question. How many times can I apply for naturalization? Well, except you are permanently barred, because some offenses can create a permanent bar, and I think I've explained some of that in the future, if in the past. So if you are convicted of aggravated felony, that can create a permanent bar to naturalization. But if you are not, there is no limit to the number of times that you can apply. If you apply for naturalization and your application was denied, maybe because you are not able to pass the civic test, or you are not able to pass the test of English, or you are not able to show that you can read or write, if you fail, your application will not be denied. Immigration will give you a second chance. They will reschedule you. You have the opportunity to go and relearn those things and come back. If you fail the second time, then the application will be denied. So if you want to reapply again, you start the process all over again. If you are denied citizenship, you can always apply again. There is no limit to how many times you can apply until you get it. However, if the reason for denial is based on aggravated felony or any other offenses that created a permanent bar, then no matter how many times you apply, you will be denied all the time. The next question: if I disclosed a crime on my green card application, do I need to disclose it again on my citizenship application? I got my green card, so I should be able to get citizenship, right? No. If you committed a crime before your green card and you disclose it, when you apply for citizenship, you still have to disclose it. As I explained earlier, certain crimes may not disqualify you from citizenship, from green card, but may disqualify you from citizenship because the requirements are different. For example, good moral character is not a requirement for green card. So even if you get your green card, that doesn't mean you will get citizenship, because for citizenship, part of the requirement is to show good moral character. So the offense that did not disqualify you for green card may disqualify you for citizenship, and the application process is different. Yes, you still have to disclose it. You still have to. And it does not mean that because it didn't affect your green card, it will not affect your citizenship. It may affect your citizenship because the requirements are different. The next question: I was arrested for DUI 6 years ago, then nothing for years. I recently pled guilty to fishing without a license. Would these offenses make me ineligible for citizenship? Well, this question didn't state when the person obtained the green card. But definitely, if this was within the first 5 years of becoming a permanent resident, yes, it will impact the citizenship. And in actual fact, these ones are misdemeanor offenses, so it is not a permanent bar. But from the date of the last conviction, you will have to wait at least 5 years before you can apply for citizenship. It will definitely impact citizenship, but it depends on how long. If, for example, if these offenses happened more than 5 years after you already have the green card, yes, it will not impact the citizenship. That is why it is important to know when this person obtained green card, because if you have already, the law is stricter within the first 5 years of the citizenship. So if this occurred after the first 5 years after becoming a citizen, a green card holder, it may not affect the citizenship. But if this occurred within the first 5 years of becoming a permanent resident, then it will affect it. Then you have to start the 5 years all over again. The next question: if you are found to not have good moral character due to minor offenses, is there a way to appeal this decision? Of course, every citizenship denial is appealable. In fact, citizenship is the only immigration benefit in the whole of immigration law. It is the only immigration benefit where the applicant has a right to ask the court, the federal court, to intervene to review immigration's decision. So if your citizenship application is denied, one, you have a right to request a review within immigration themselves. Two, if the review is done and they stand by the denial, you have a right to request the federal court to intervene and review immigration's decision. So this is as of right, and citizenship is the only immigration benefit where an applicant has such a right. For any other application, you cannot challenge immigration in court for denying it. No. If it is a kind of application that you can appeal, you can file an appeal. But usually, application for green card, application for permanent residence is not appealable. So if immigration deny it, the only thing you can do is to file a motion to reopen. If they deny it, there is no right of appeal. But for citizenship, yes, you can request a review with immigration themselves. You can also request a review at the federal court, federal district court. The next question. Okay, I'm not sure if this is the next question. If I disclose a crime on my green card appeal, do I need to disclose the crime? Oh, I think I've answered that. I was arrested for the year 6 years ago, then nothing for you. I think I've answered that too. If you are found to not have good moral character due to minor offenses, I think I just answered that. Okay, the next question. I have a lot of unpaid parking tickets, but I've never been arrested. Could this still block me from getting citizenship? No, it cannot. As I stated before, any offense that does not lead to arrest will not impact your citizenship application. But you have to be sure, because when you start accruing a parking ticket, sometimes I've seen tickets lead to arrest, especially where the one giving you the ticket is a government authority, whether it's the municipal government or is the state government. So tickets sometimes can lead to arrest, because after you accrue so much ticket and no payment was made, sometimes the local authorities, the municipal authorities, or the state authorities, depending on who is handling the ticket, may go to court and request a warrant of arrest. So if it ever leads to arrest, the issue here is that once somebody is arrested anywhere in the United States, it doesn't matter who is making the arrest, whether it is state, the local authorities, municipal level, federal, no matter who is making an arrest, once an arrest is involved, the first thing they do is fingerprinting. Once an arrest is involved, the first thing is fingerprinting. And the problem with that is that as soon as you are fingerprinted, it goes into the national database. So it means for life until you are dead. Every time they are asking, have you ever been arrested? You have to keep answering yes. Because the moment you answer no, and then they see it, they see you as lying. So even though ticket naturally does not impact citizenship, you don't want to wait until ticket becomes an arrest issue. I remember I used to have represented a client who was driving, who was a who was, I don't want to call him a cab driver because he was not registered to be driving a cab, but he was driving the cab anyway. This was before the introduction of Uber. This was before Uber. So he was driving. So he will always drive to the airport, pick passengers, and leave. So they will stop him and give him ticket. Sometimes he will pay the ticket, sometimes he will disregard it, but he kept on doing it. So at a point, it led to his arrest. And guess what? When he applied for citizenship, it was denied on that ground. Immigration claimed that he lacks good moral character. He has no respect for the law of the land because the law of the land says do not go to the airport to pick passengers except you are registered at the airport. And he was doing that without being registered. Like I said, this was before the days of Uber. So, yes, tickets may look simple, but don't let it pile up to the extent of you being arrested. If you do, then it can impact your citizenship application. The next question. On my green card application, I did not mention offenses I committed with a different name. Is it better to disclose this when applying for N400, or should I just pray they don't find out? What a very, very good question. This is a very, very good question. I'm going to tell you, it is better to disclose it. However, let me give you a caveat. I don't know who sent this question because I just got the question. I'm not able to see the name. I think that was on the number where the question came in. I'm not able to see the name, so I'm giving a general question here. But my first advice to whoever sent this question, I think it's better to schedule a consultation appointment to seek professional advice from an immigration attorney. It doesn't have to be me. Because the reason I'm saying that is that certain things are not clear from this question, and I don't want to mislead you. But one thing I will tell you, it is better to disclose it. Of course, when you disclose it, they are going to deny your citizenship application. But it is better to deal with it now than to leave it for the future. Because in the future, the impact may be more drastic and significant. Non-disclosure. I was explaining earlier that the only time that a U.S. citizenship can be revoked is when immigration can prove that the citizenship was obtained by fraud. This is a clear example of that. If you don't disclose it and immigration didn't find out and you become a U.S. citizen, 5 years down the lane, 10 years down the lane, at any stage when they found out, they will revoke the citizenship. In fact, based on this fact, let me give you another example. I know of someone who has been a U.S. citizen for more than 10 years. In fact, American passport is valid for 10 years. He has used one American passport. It was in the process of renewing his passport. Remember, once you become a U.S. citizen, you don't go back to immigration. You don't have anything to do with immigration except you want to sponsor somebody. This person did not file any petition for anybody, so he didn't have any reason to go back to immigration. But guess what? It was in the process of renewing his American passport that the Department of State found out that he has used a different name before, which he didn't disclose. Because he was already a U.S. citizen, they have to involve the court. So, he was charged to court. What was his offense? 1, obtaining American passport by fraud. 2, obtaining American citizenship by fraud. They gave him those 2 counts. So, as I speak to you, this person is still in jail. And he has been American citizen for more than 10 years. So these are some of the dangers of non-disclosure. But when you disclose it now, 1, it is not a crime. The worst case scenario, immigration will deny your citizenship. That is the worst case scenario. If they deny your citizenship, if they don't do anything more than that, you keep using your green card. If you still want to become a US citizen, you apply for a waiver. If they deny your citizenship and put you in removal proceedings, you go to court and seek removal defense. Depending on your situation, you may be eligible for 237A1H waiver. You may be eligible for cancellation of removal for permanent resident. You may be eligible for 212H waiver. So there may be a lot of things. So it is better to fix the problem. Once you fix the problem and the problem is resolved, then you reapply for citizenship. That issue cannot come up twice. That is what is called the principle of res judicata. They can only use it against you 1 time. Once they use it and you resolve it, case closed. They cannot bring it up the second time because it is barred by the principle of res judicata. Let it rest. That's what it means. So, it is better for you to disclose it at this stage, deal with the issue, and then resolve it, than to leave it hanging, because it can still be an issue even after you become a US citizen. The next question. You mentioned stealing is a crime of moral turpitude. Does it mean then that someone convicted of stealing cannot adjust the status to permanent resident? Well, somebody convicted of stealing, if they have the waiver, can still become a permanent resident. It's a crime of moral turpitude, but usually for crimes of moral turpitude, waivers are allowed where the applicant has a US citizen spouse or US citizen minor children to serve as a qualifying relative in order to apply for a waiver. Yes, you can still get your green card if you have a qualifying relative. Qualifying relative can be US citizen or permanent resident spouse. It can be US citizen or permanent resident minor children. It can be US citizen or permanent resident parent. So if you have any of these, yes, you can apply for a waiver of ground of inadmissibility. So you file Form I-601 and apply for the waiver. After that, that case is resolved and you move on. Okay, I think that's the last question I have here. Do you still have anyone over there? Okay, I think that is the last question for today. And I also see that it's already 1 o'clock. So we are going to be rounding up today. Next week is another day. Remember to join us. Remember to invite your family, friends, colleagues. You will agree with me that we provide valuable information on this podcast. Unlike most other podcasts where they will tell you, oh, there are 4 things. If you want to listen to the 4, do this, do that. We don't do that here. We provide all this information to help our people because we believe very strongly that the difference between those people who are struggling and those people who are making it, the major difference is information. And that is the only thing we can offer, to provide the information on this platform free of charge. However, we can only provide the information. It is left for you to take advantage of it. It is left for you to follow the advice. We cannot force you. One can force a horse to a river, but you cannot force the horse to drink water. So the only thing we can do is to provide you this information, and that is what we are doing, and we intend to keep doing. So every Wednesday, 12 p.m. Central Standard Time, that is 12 p.m. Dallas time, we do this every Wednesday. So subscribe to our channel so that whenever we go live, you can be notified. And you can also follow us on our social media platforms. You can follow us on TikTok. You can follow us on Instagram. We do have a short clip of information on daily basis. So you have different ways of following us and getting all this information. We do all this free of charge as our own contribution to humanity. So I hope to see you again next week. Remain blessed and have a wonderful year 2024.
Call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I said, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I pared his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking. But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.